Former acting Attorney General Matthew Whitaker joins me now. Matt, thanks for being here. I first want to take us back to what happened with Donald Trump today, because he's facing in New York this gag order. We don't know exactly how the judge is going to rule on whether he's violating it or not, but could what we saw this morning, Trump going out and campaigning, be considered something that he shouldn't be doing with a gag order? And if so, isn't that direct election interference with his campaigning for the presidency?
Yes, it would be, David. Good to be with you. I think the judge is going to be more focused on what he's sending out on Truth Social about witnesses, especially. I don't think, he is certainly entitled to campaign, and he is certainly entitled to do it outside of court hours on Wednesdays and on weekends. But that being said, we are very close. If this court muzzles him from doing anything outside of court, then I think that is clear election interference. But this whole thing, as you know, is election interference because it's keeping him off the campaign trail.
It is indeed. And I just wonder what's going to happen about his decision to appear as a witness. A lot of people, a lot of lawyers are saying, look, let the court hang itself on this case because they've been making so many mistakes, this court in New York. What do you think? Should he avoid becoming a witness and give them any kind of information they could use against him?
Yeah, David, I've tried cases both as a prosecutor and a defense lawyer. You don't make that decision until the end to see how the evidence comes in, how you feel it's going with the jury, the read you get on the jury. So it's premature to say that. I like his attitude that he's unafraid to take the stand, but he might not have to because the case is so weak.
All right. Let's move to the immunity case. This is really a big one because it could affect Jack Smith and whether he gets a trial before the election or not. It's looking at whether Trump, as president, had immunity to do what he did after the election, specifically January 6th, but all the stuff leading up to that, and did that, and I'm going to use a complicated phrase here from an old Supreme Court decision dealing with Richard Nixon, did that fall, quote, within the parameter of his duties? What do you think about that?
Yeah, well, I think what he did is most likely did fall within his duties, but the challenge that the Supreme Court's going to have today is there's been no fact finding. So other than the papers that have sort of been alleged, the court has no facts. The trial court has no facts. And so I think one of the most likely outcomes is the Supreme Court sends this back to Judge Chutkan to try to get some factual basis so they can make this decision. But that Nixon case, there's a Clinton case, but there's no criminal extent of this case. And one thing I would point, David, remember the hullabaloo around if he ordered SEAL Team 6 to assassinate a political opponent? That's not the hypothetical they're going to hear today. They're going to say, what if he orders SEAL Team 6 to assassinate a terrorist? Can he be held liable in the court of international criminal? And so that's a more interesting scenario. And that's why I think he's going to get a lot of benefit of the doubt on the immunity question. Right.
By the way, Trump lawyers didn't bring that up. It was the judge with a very hypothetical case. And the answer was not as the media responded. The answer was very carefully phrased. But very quickly, if the Supreme Court sends it back to the courts, does that delay this trial until after the election?
Yeah, I think there's little likelihood at this point that this case or any of the other cases, except for the current trial, are going to, make this November deadline. But that being said, Jack Smith really wants to try this case before the election.
Yeah, he's salivating. Matt Whitaker, thank you so much for being here. Good to see you, my friend. Appreciate it.